Well, good morning and a very good afternoon to those of you who are joining us from Europe. I'm Liz Stern, and I am a Mayor Brown partner in Washington, D.C. I am the managing partner of the D.C. office, and I have the pleasure of working with my colleagues who are here from Mayor Brown, and have had the great pleasure of today meeting Pierre-Hugues Verdier, who we think has written what will become the seminal book on a highly novel evaluation of the changes in global financial standards stimulated by U.S. prosecutions. Let me begin by welcoming you and letting you know that we are recording today's session. So it will be sent to you through a link after we conclude the session, and don't hesitate to let us know if there are others who wish to receive it. In addition, we welcome your questions. Feel free to post questions to the chat room. We will get to them at the end, and if we run out of time, we'll address them through some sort of FAQ as a follow-up mail out to the attendees. We have the pleasure of having a highly robust attendance today, and we think it speaks to the innovative aspects and importance of Professor Verdier's book. We are delighted to welcome you, Pierre-Hugues. We think that it is just terrific to have you here. And I know that the professor is coming to us live from the University of Virginia's School of Law, from his office, as you can tell from the books behind him. I have a particular affinity for that because I am a graduate of UVA Law much longer ago than I will be willing to admit, Professor Verdier. But I could tell from the way the light is falling. I knew that had to be where you are. Professor Verdier is a John Ewell Jr. Research Professor of Law. He earned his JSD at Harvard Law, clerked at the Supreme Court of Canada, and worked at Cleary Gottlieb in New York as part of the long list of his achievements. He is the definition of cross-border, since he has lived cross-border and multi-jurisdiction. And he will tell us today how his interest evolved in international financial regulation, enforcement, and standards, and that evolution. Professor Verdier's book, Global Banks on Trial, U.S. Prosecutions and the Remaking of International Finance, was published by Oxford University Press in 2020. His book is a groundbreaking account of how, as one reviewer put it, U.S. prosecutors, leveraging off U.S. dollar dominance, may have become the most powerful regulators of international finance on this planet. What a powerful statement. Professor Verdier examines two somewhat contradictory views. One, whether U.S. bank prosecutions are a form of prosecutorial imperialism by which the U.S. can weaponize its control of international finance towards its own ends, or two, whether in contrast, these enforcement actions can lead to beneficial reforms. You will hear his analysis, insights, and conclusions during our discussion today. Professor Verdier will be joined in conversation by Joydeep Sengupta. Joydeep is admitted to the Paris, New York, and Ontario bars, and I believe is broadcasting from Paris today. He focuses on cross-border litigation, compliance, and enforcement matters for major financial institutions and corporations, including the resolution of administrative and enforcement proceedings involving both regulators and prosecutors. In addition, Gina Parlovecchio is with us today, and I think you can tell which of our colleagues Gina is. Gina is a leader in our white-collar and investigations practice, as she served as an assistant U.S. attorney in the U.S. Attorney's Office for the Eastern District of New York, where she was chief of the office's International Narcotics and Money Laundering section. She will provide a commentary and insights on the discussion. Because as a federal prosecutor for over a decade, Gina has investigated, prosecuted, and tried some of the Eastern District of New York's most complex, sensitive, and high-profile cases across a wide variety of areas, including some of the areas that we're talking about today. Among many other honors, Gina was recently named in Crain's New York Business Notable Women in the Law. In addition to Gina, our final commentator today is Mark Cohen, my good friend and partner in Mayor Brown's Washington, D.C. office. Mark has watched and reviewed and influenced the way that regulatory developments of financial institutions have evolved over the past 25 plus years. Mark regularly represents global financial services firms on litigation, banking and securities, regulatory, enforcement, legislative, and strategic counseling matters. He will bring his insights to the fore, particularly because he works with all of the U.S. financial regulators, the Federal Reserve, Treasury, the many subdivisions within Treasury, FDIC, SEC, and state banking and insurance departments, as well as Congress, because of course congressional investigations often creep into these types of major issues. He also deals with non-U.S. financial supervisors. Just finished telling us how he spent 20% of his life in Switzerland and quite a bit in London as well. And I think that Mark will bring such a rich comment to the table in the discussion. Global banks have been a signature industry for Mayor Brown for a very, very long time. And for us, it is a privilege to be opining with Professor Verdier today on this topic. Today's talk could not be more timely, given the recent statements from the U.S. Department of Justice regarding its increased focus on prosecuting corporate crime. So without further ado, I pass the floor to my colleague, Joydeep Sengupta.
Thank you so much, Liz, and thanks again, and welcome to all our colleagues. And we notice people are joining us all the way from Australia to Paris to New York, so welcome, and Switzerland. So we're thrilled to have you all with us. And it's my absolute pleasure to welcome Pierre-Hugues as well. The two things we share in common is we're both Canadian and went to the same law school, McGill, so where we studied comparative law. So we're thrilled to have you here. Without further ado, this is a great book, and too bad during the pandemic it didn't get the attention it deserves. So we are delighted to be able to share this with a broader audience. First question for you, Pierre-Hugues, what inspired you to write this book?
Well, first of all, thank you very much for this very kind introduction and for the invitation to speak to this group today. I'm thrilled to be here. Now, the book is really an extension of earlier work and an earlier interest I had in the regulation of international finance more generally. So for several years, I had been teaching and writing on that topic, and the focus was very much on regulatory agencies like the SEC, the Federal Reserve, the FSA, other banking regulators around the world, how they cooperated through organizations like the Basel Committee on Banking Supervision on cross-border issues. And of course, when the 2008 financial crisis came along, that made a huge difference in that world. And the system that I was just describing went through a round of major reforms. The Group of 20 became much more directly involved in setting the agenda for international financial regulation. The Financial Stability Board was created. And the new structure tried to coordinate various substantive reforms, very important reforms that came out of the financial crisis: capital and liquidity standards, cross-border resolution, derivatives, the list goes on. And so in the world I was in, people paid a lot of attention to these reforms that came through what I would call the formal system, the traditional system, overhauled as it was. But what struck me at the same time, just looking at the news and looking at what was going on in the world of bankers, was that there was a very noticeable development in corporate criminal law as it affected global banks. The DOJ and other prosecutors kept announcing high-profile cases, larger and larger settlement amounts, and the targets were not the traditional targets of criminal enforcement in general or corporate criminal enforcement. These are banks, global banks that 15 or 20 years ago, it would have seemed almost unimaginable that they would be involved in these kinds of prosecutions and have to face DOJ as their main nemesis. So I thought, well, there is something important and notable going on here that is not getting a lot of attention from the financial regulation crowd. So, and one aspect of it that was particularly interesting is that once you started looking beyond the settlement that a single bank entered into on a specific topic, you saw that there was a pattern, that there were series of resolutions with several global banks on the same topic that often incorporated very extensive compliance reforms that seemed to be carried from one settlement to the other. So the issues that were being addressed were not just punctual issues within one bank, but they were systemic. And they were often different from the issues that arose directly out of the financial crisis. They were on different topics. So it started looking to me like there was a sort of parallel regulatory agenda that was now being pursued through corporate prosecutions and settlements with global banks. And I thought this was worth studying. So that was the genesis of the book, so to speak.
Well, excellent reasons. And for those of us, as Liz mentioned, Mark and I both work on these cross-border investigations, and for Mark for over 20 years and myself for 10 years. And we've seen a true evolution, also a sophistication on the side of the clients that have been facing with these operations, the investment of resources that have gone into the remediation programs, the compliance programs, and as well as more cross-border cooperation, which I know Gina will talk about as well with the regulators and prosecutors overseas. Before we go on, what do you mean by a global bank? I think this is something interesting that let's discuss the nomenclature right, get the nomenclature right. And so it would be helpful if you tell us what is a global bank for the purposes of this audience and why do they matter?
Yeah, on its face, it's not the most precise term. And so for purposes of the book, I needed a somewhat more precise definition. And what I did is that I simply defined global banks as the group of banks that were on the FSB's list of global systemically important banks, the GSIBs list, at some point during the period that I was looking at between 2008 and 2016. So those are the largest, most interconnected, most internationally active banks in the world. And I give some background on how they came to be as institutions to be the banks we know today. They're really the result of decades-long trends of consolidation of the banking industry, both domestically within their own jurisdictions and across borders. And today, we have a system that has a fairly small number. I think there are 34 banks that make my list, and some of them are not quite as internationally active, like the large Chinese state-owned banks. But most of them are, well-known names, and they share these characteristics that make it so that the FSB designates them mostly for the following reason: because they're concerned about financial stability, and those are the banks whose failure would create or is thought might create systemic risk. So they're designated for purposes of imposing greater regulatory requirements on them, capital standards, stress tests, resolution plans, and so on. Now, my goal in the book is a little bit different, but I think the classification still works. The reason I look at these banks is that first, they are themselves important hubs in the international financial system. All kinds of other users of international finance, so to speak, go through the banks to access payment services, clearing and settlement. Many of the different functions, central functions of the international financial system have banks as sort of gatekeepers. And the second reason is that they themselves, the global banks, are dependent on international financial infrastructure in a way that gives the United States leverage over them when they are faced with the possibility of criminal prosecutions. So my hypothesis was that by targeting them, prosecutors are not just sort of fighting crime where they see it. They're not just going where the money is to try to get big settlements. They are pursuing a bigger agenda, which amounts to leveraging the power the United States and specifically has over these financial hubs to address what they see as systemic problems and advance policy goals. So this is not just about individual prosecutions or corporate prosecutions, but it is about a larger system that is evolving, I think.
Absolutely. And from our perspective as practitioners in this area, as I'm sure Mark will confirm as well, that we often see these banks are most active in some of the very everyday transactions like correspondent banking and trade finance, and that's where we see a lot of the exposure in some of the topics that you cover. And for those of you who have not read the book, we highly recommend it. And the 4 areas that it covers are LIBOR, foreign exchange and other benchmarks, facilitation of tax evasion, sanctions violations, and he also looks at sovereign debt. But all of these topics, come to us in different ways. But from a practitioner's perspective, it's the everyday transactions, it's the things that you think are routine. That's where a lot of the big risks come out. So going to kind of the book itself, which is also eminently readable. It doesn't read like a kind of an academic book. It's something that it reads like you could sell it in an airport and people would find it interesting. So you argue that the rise of criminal prosecutors as active players in international banking has had a major impact. I mean, we from a practitioner's perspective, we absolutely agree, and we've seen this on both sides of the Atlantic. How would you explain that thesis?
And I guess before I answer that, I will say I very much appreciate your comment on readability. It's not easy as an academic to write a readable book. We're not really trained to do that. So I'm glad that you find that to be the case. So with respect to the role of prosecutors, well, that's really the first big takeaway from the book in my mind. Prosecutors have now become players in that world and overseeing and enforcing the law against global banks, if you will. And the key point here is that they are different from the traditional regulatory agencies that global banks were used to dealing with in important ways that make us think about the evolution of the regulatory system and how it's affected by their presence. So the first thing that's different about them is their incentives. Their incentives are very different from those of regulators. They respond more directly to public concerns, even to political demands than independent agencies that banks traditionally deal with. And the post-crisis era, that meant pressure to show that they were doing something in response to what was seen as kind of widespread misfeasance in the financial system. So I think that explains not necessarily any individual prosecution, but the greater focus on white-collar crime in the immediate aftermath of the financial crisis, and that's a big factor in a lot of these cases being brought. If you look at the career incentives of prosecutors, they tend to favor robust enforcement. To be seen as successful as a prosecutor, to go on to other jobs, you have to show results, and the results usually are cases won or cases settled on what is seen to be favorable terms. So that's also something that pushes them in directions that are quite different from traditional banking regulators. And also they're generalists. They're not, they're responsible for enforcing the law in general. They are not so concerned or directly responsible for things like the health or the stability of the banking industry. They don't have the same ongoing relationships with people in the industry that they try to have to, or that they have to try to maintain and preserve. Even when they're thinking about their enforcement work. And they don't have the same kind of relationships with their foreign counterparts that regulators do, where they have to be careful about stepping on the toes. For example, the Fed has to be careful about stepping on the toes of the Bank of England and vice versa. I think that's much less of a concern for regulators. So the quiet sort of behind the scenes work that is the hallmark of bank supervision is really foreign to the culture of prosecutors. So that's the first difference. The second difference is about their tools. They can do many things in criminal investigations that regulatory investigators, traditionally at least, did not really do much of. Put pressure on witnesses within the organization with the threat of individual charges, go undercover, even wiretaps in a few cases. They are used to working with whistleblowers, with other kinds of inside witnesses. So that means that compared to regulators, they're better positioned to target specific kinds of cases, especially cases where what you see is a suspicion that people are engaging in intentional deception. And this is not something that regulators are very good at investigating because of the tools that they have, but prosecutors and their agents have much greater capabilities there. And finally, one thing that's very important about what's going on in this space is that global bank prosecutions did not arise in a vacuum. They are sort of an outgrowth of a much bigger trend of corporate criminal prosecutions that started in the late 1990s and then get bigger and bigger over the course of the early 2000s, where the Department of Justice and U.S. prosecutors in general brought thousands and thousands of cases against corporations for violations in all kinds of areas of law, and the environmental laws, labor, immigration, many other things. And so there's a toolbox that's been derived from that activity that prosecutors have put to work in targeting global banks. Now, in the early years, the threat of criminal indictment and conviction was thought to be almost a death sentence. Arthur Anderson was still fresh in people's minds. Many feared that you could only push things so far. But since then, there have been several guilty pleas from banks that did not collapse. So the threat has dissipated a little bit, but they still have a range of very powerful tools that are not the ones that banks are familiar with from their interactions with regulators. So in practice, what does that mean? Well, prosecutors have focused on areas sometimes that were neglected by regulators, sometimes with much greater impact. And one case that I look at in the book that I think is a clear example of that is LIBOR, where there were news reports and studies that suggested possible manipulation as early as mid-2008 during the financial crisis. And I think it's very clear at that point that regulators were not so concerned about the possibility of manipulation. They were much more concerned about the financial stability implications of what was going on, and even of kind of bringing enforcement actions against the banks at that time. So they looked at it. The BBA proposed some fairly minor reforms at the time. The regulators went along, and not very much happened in retrospect. Whereas behind the scenes, the CFTC, the DOJ continued to investigate. In 2012, criminal settlements began to come out, starting with Lloyd's, created a huge scandal. And this led directly to the reforms of LIBOR that we see today that are taking up so much time from people who are in banking practice. The LIBOR transition is still going on. So this is an example of prosecutions having a systemic impact in the way that regulatory action at the time did not.
Got it. I'm conscious of the limited time that we have, so I'll try to kind of move along some of our questions. We'll have about 10 minutes towards the end, so to make sure that Gina and Mark have some time as well. But it'd be interesting. There's a couple of conclusions that you draw in this book that we thought were really fascinating, and especially your takeaway about the impact of unilateral action, whether that's a positive or negative thing from a systemic perspective. And so, tell us what your conclusion is there.
Yeah, and this is the place where the book takes a somewhat contrarian view, at least relative to some of the critics of these actions. Because I argue in the book that at least in some circumstances, the kind of unilateral action that the United States has been taking through these prosecutions can have a positive impact on problems that had seemed almost intractable before then. In other words, unilateral does not necessarily mean self-interested or damaging or going against the interests of other states. I think the LIBOR and FX cases illustrate this. I think the reforms that are coming out of these actions are positive ones that are going to benefit everyone to be moving away from benchmarks that were vulnerable to manipulation to something that's more robust. A case that I think is even more instructive is the tax evasion cases. So for years, I think it was well known that onshore jurisdictions, not just the United States, but many other countries as well, lost a lot of tax revenues to residents who moved their assets offshore, did not report their income. But all multilateral efforts to try to deal with this problem for many years really didn't go anywhere. And what made a huge difference, I think, if you look at this problem as it evolved over time, what made a huge difference was the emergence of U.S. prosecutions. Starting in 2009, I think, was when the case against UBS came out, which was a case that started with a whistleblower within the bank who brought information to the DOJ and the IRS, and then was followed by other prosecutions along the same lines. They targeted foreign banks that provided undeclared accounts to U.S. customers. And I think what's really remarkable is how this kind of snowballed over time, not just into more and more prosecutions, but into a bigger reform effort that ended up benefiting not just the United States, but I argue other countries as well. So the UBS resolution came along with subpoenas that forced the release of thousands of US client names. The US tried the same with other banks, but the process proved pretty cumbersome, too slow. There were lots of legal obstacles in Switzerland itself. So the United States ended up demanding amendments to the tax treaty to make it easier to share information. And this was a big breakthrough. This broke with decades of Swiss policy as to what they were willing to give. And even with that, US lawmakers were still disappointed with how slow the process was. So the prosecutors ended up before Congress getting grilled about how slowly they were solving this problem. This led ultimately to the adoption of FATCA, which threatened foreign banks with a withholding tax unless they provided information on their US customers. And at that point, Switzerland and other offshore centers gave in. That under the threat of FATCA, they basically agreed to release much more information than had been available in the past. And then other countries jumped on that bandwagon. Prosecutors in France and elsewhere started knocking on the same door, asking for information from Switzerland and a few other jurisdictions within Europe that had resisted information sharing for a long time. And once these gave up, then at the international level, the broader front of jurisdictions that had resisted information exchange basically collapsed. So the project that had existed a long time at the OECD to have a system for automatic exchange of information that had been blocked forever just finally went through. And we have a system now for automatic exchange of information, which has its holes, but is something that if you look back before 2008, is something that people would have found completely unimaginable that this would be successful. And the momentum.
Just to interrupt you for 1 second, I just want to call out Mark, since he's been at the forefront of a lot of these tax cases in Switzerland for many years. So Mark, I don't know if you want to share your experience as a practitioner in that front.
I'm going to spend some time in my commentary afterwards, but I would agree that this was really a catalyst for a bigger change, and I think Professor Verdier has that just right. The question I'm going to delve into a little bit, and the book delves into, is whether the exercise of prosecutorial power has proper constraints. It does perform the function you said, but and it certainly did in this case. But the question I'm really grappling with is, how can it perform the same catalytic effect, but without some of the negative effects of things that where proper constraints don't exist? But I think you have it just right in terms of the really important effect of this and the changes that go well beyond even this topic that were affected by that prosecution, or those prosecutions. And the real question that you grapple with is not really why it happened then, but why did it take so long? And I think that's people say, why is this happening now? But often the case is, well, this is something that really could have happened before, so we have to look at why did it take so long, and I think you do that really well.
No, thank you, Mark. And that takes us to my next question, which is also related to the thesis that maybe this was a good thing, but also not every country could do this, right? So every country didn't have this level of power over the global financial system and US dollar clearing. We know in Europe that the threat of New York being taken away as a jurisdiction for US dollar clearing is often the biggest stick hanging over European banks that would lose access to a very, very important market, which we've experienced in some of these cases. So tell us, Professor Verdier, the very unusual role that has been played by US authorities in prosecuting financial crime involving global banks, and how in particular has the US asserted jurisdiction? Because that has often been the source of contention. We know in some FCPA cases, this is my favorite, somebody was on a conference call and the fiber optics went through the US and crossed state lines. So that was used as a nexus to assert jurisdiction. So the US can get very creative, right? So dollar clearing is one, even when for certain sanctions transactions, there were U-turn exemptions for transactions that began and ended in Europe, but the touch point being in the US then brought them into both the DFS and the DOJ's jurisdiction. So tell us what that has been like for you, and what have been some of the responses from other countries, and we can talk about France too. Go ahead.
So that's something that really struck me in doing this research. And then part of the background to that is that I'm an international lawyer by training, and in the past I'd studied things like the jurisdictional disputes of the 1980s over extraterritoriality. And if you look back at that history, countries like the United Kingdom and France really pushed back, not just from a political standpoint, but from a legal standpoint. They seem to be fighting constant battles against extraterritorial assertions of jurisdiction by the United States in areas like antitrust and sanctions. Some of these cases back then ended up before the US Supreme Court. Countries adopted blocking statutes. There were battles of anti-suit injunctions when there was civil litigation. It was a big legal battlefield. And by contrast, I think it's fair to say that there's been very little by way of legal challenge to what the United States has been doing in the cases that I'm looking at more recently. And there could be a couple of reasons for that. The statutes, the criminal statutes that the DOJ is using, wire fraud, conspiracy, and so on, as a basis for these actions, they're extremely broad. It's always possible to fit, at least in a credibly enough to go to settlement negotiations to characterize what's happening as a violation, even though we don't really know what would happen if it actually went to a jury. In respect of territorial jurisdiction, of a geographic scope of this, as you pointed out, in most of these cases, the United States can argue that part of the violation occurred in the United States or through the use of US facilities like payment systems or communication systems and so on. And they assert that that's enough. Now, I think there would have been plausible legal challenges to at least some of these cases under US law, especially given the recent Supreme Court case law on extraterritoriality and personal jurisdiction and how restrictive it has become. And I actually argued this in a separate law review article a couple of years ago. But the reality is that these points were raised by individual defendants in a handful of cases. And some of them even won little victories here and there. But the banks, as far as I'm aware, never really did raise these points, or certainly not before courts. And I think that's just a reality of corporate criminal prosecutions, especially for banks. The perception is that the cost of defending the case and losing, or even having the case pending for a long time, is such that banks just decided that fighting these points just isn't worth it. So
I can interrupt you there just for 1 second from a practitioner's perspective too. And Mark, we've seen this in the sanctions cases where there's an actual conflict in public policy, right? So in Cuba and Iran in particular, you've seen a lot of differences of approach. And there you had strengthening of the European blocking statute and discussions within at the EU Commission level on what to do as a response, because it's a policy conflict. And then if you're a global bank, you want access to both markets, you're kind of caught between a rock and a hard place. But ultimately you have to make a choice. Who has the bigger stick? And I don't know, Gina, if you want to chime in from your perspective as a prosecutor for the DOJ, working with your counterparts in Europe when you were at the DOJ.
So, there has been increased cooperation between the U.S. and its foreign counterparts especially over the last 4 years, because there's just been as Professor Verdier points out in his book, a sort of waning of corporate investigations in the U.S. So there has been increased cooperation, and as a result, because there's a more active enforcement environment in the EU and the UK, there's been more of an appetite for collaboration and sharing of evidence. So it's helped U.S. prosecutors navigate some of those blocking statutes and privacy laws that had historically been so difficult for them to deal with over the years. And so I think because of that, you're seeing more cross-border cases being brought. I think you're going to see even more of that. And I know we'll get to what's going to come next later in the discussion. But I do think the increased collaboration is very much a trend that we're going to continue to see.
And for just to come back to this point of the US's power, the other issue which is also the imbalance of power. So if you're a corporate defendant, and which is often we're representing the institution or the individuals, and there's been wrongdoing by a few bad apples somewhere, And it's very difficult as a corporate defendant to kind of risk your entire financial institution reputation by going to court. So you're much more pressured to settle and incur expenses, and even, you know, accept certain sort of characterizations of facts which you would otherwise really want to contend.
Yes.
That takes me to my, yeah, go ahead.
Oh, and the DOJ places such an incredible premium on cooperation in terms of how the settlement resolves, and that's actually, you know, the recent speech by Deputy Attorney General Lisa Monaco, you know, really reemphasized that. So you can see how financial institutions and clients are feel that pressure to cooperate rather than fight these extraterritorial issues that we just discussed.
Mark, do you want to talk about any of your cooperation experiences, how that's played out? We can't hear you, sorry, Mark.
I wanted to just raise that in terms of cooperation, and this is a point Professor Verdier makes very well. It's a very insightful one, that what Gina described in terms of the increase in international cooperation is one of the effects of aggressive U.S. prosecution, that it has had that catalytic effect on what other countries do and how they look at France. You know, Joydeep is a great example. But also, that is a way, going forward, this cooperation is a way potentially to address the criticisms of U.S. overreach. Because to the extent multiple authorities are involved, then the French authority, UK, Swiss, German, wherever, can say, okay, we're working with you on this. We get this, but this is really our primary concern. This is in our jurisdiction. And therefore, since we have a robust function here, that we should take the lead. And I think over time, there's going to be give and take among the prosecutors and authorities to, I hope, get the balance right. So it won't be viewed as U.S. imperialism or U.S. overreach, but rather collaboration that really lets disputes to be primarily resolved where they primarily reside.
And we're in the thick of it right now in Europe, because you know, as we'll get to eventually, because there's been a proposition of law in France in particular to strengthen Sapin 2, which is our anti-corruption law. And that has several jurisdictional pieces, additional protections for corporate defendants. So we're living in very exciting times when this entire area of law is fully in evolution and responding to political change on both sides of the Atlantic. So somebody was about to interject. Sorry, I interrupted.
Oh, I was just going to say very briefly, this issue that Mark points out, the DOJ tried to address it over the last several years by instituting the anti-piling on policy. So prosecutors in the US are supposed to take into consideration what their foreign counterparts are doing, what types of settlements they're reaching in crafting their settlement. So it is something that prosecutors have taken notice of. The question is, will that continue in this administration? But
and that's an argument, obviously, we as advocates constantly make after that memo was published, that, you know, this is piling on and there should be proportionality. And the other challenge with these agreements is that, you know, each settlement is a contract, right? So it is not like case law, so it doesn't serve as precedent. So you kind of have to be do some creative lawyering to remind, you know, the authorities that they have to be treated like conduct in the like way. So that issue comes up often. And it goes back to, you know, the credit you get as incorporating France. We often find that, you know, when these types of investigations were beginning, French defendants, especially corporate defendants, were not used to giving up their own incriminating information to their prosecutorial authorities. It was quite a shock to our system, and so it took a long time for even the very large, sophisticated or financial institutions to become comfortable with giving up this information and then seeing the impact in terms of reduction of the fines, as Gina mentioned. Going to the next question, what are some of the common themes, Professor Verdier, you found when you looked at these bank cases and that may have caused these violations? So what went wrong in these cases?
Well, that's a very interesting question, because what I realized is that when you start looking at these violations from inside, so to speak, in terms of what's going on in the institution, it struck me that they're very different in terms of the nature of the wrongdoing, who benefited from it, what their position within the bank was. In the LIBOR cases, for example, this was something that was mostly happening at the level of traders and LIBOR reporters within the banks. And those were people who had thick connections with each other across different institutions, and sometimes with brokers and other third parties who were involved in some of these actions. So they kind of exploited these relationship networks they also exploited the lack of focus by internal compliance on this particular issue that was seen as sort of a pretty minor back office function, and lack of resources in internal compliance. So I think this was, a fairly classic case of bad apples for most of it. Then you look at cases like tax evasion and sanctions. Well, tax evasion, you had entire units in some banks that were operating on the margin of what was legal, at least as far as the United States was concerned, like actively pursuing the business of US clients. Not exactly clear how visible that was within the organization, since it was not, all things considered, that large a business. But you have there are violations that could be argued to be somewhat more systemic and could have a greater risk of being attributed to leadership. And then in the world of sanctions, you have something completely different. Those are the most sensitive cases because, at least in some cases, for some banks, there seem to be very high-level decisions being made that we will keep doing business with certain countries or entities no matter what the United States says, because the United States' assertion of jurisdiction or trying to enroll us as enforcers of these sanctions is just illegitimate. And we are not US persons, and therefore, as a matter of high-level principle, we should not be subject to US sanctions. And I think what the outcome that led to is that, first, I think it made the prosecutors very eager to send a message through some of the largest penalties that arose in these cases. And it also demonstrated that when you're facing issues like this, perhaps kind of rules of thumb are not good enough. The prosecutors were quite willing to go into the details and say, for example, no, because even if you are a foreign bank dealing with a foreign sanctioned entity, and you may think that you're not subject to US sanctions, the fact that this goes through the US payment system and ultimately has flows of funds through the United States, and that you are causing people in the United States, i.e. your affiliates that are processing the payments in New York, is enough for us to assert jurisdiction, and we will do that. So it's really faced them with a situation where the question is not so much about whether anyone thinks that this is legitimate or not, but whether the US cares and has the means to enforce.
Absolutely.
So red flag.
No, absolutely. And it's interesting you mentioned the sanctions cases, because, and those being some of the most sensitive ones because of this question of legitimacy of assertion. And from a practitioner's perspective, when, a lot of these cases, the criminal law comes in when there's mens rea, right? So when there's intentional wrongdoing. And in many of these cases, we've had to argue that there wasn't intentional. In some of the resolutions where there wasn't a guilty plea, where we managed to negotiate, DPAs without a guilty plea, and of course there have been some cases with guilty pleas. That has been the crux of the argument, that they did not know, they thought they were doing the right thing. It was consistent with, let's say, France. It was completely fine to do transactions with Cuba in euros, so changing the currency, they weren't aware that that would trigger US jurisdiction. And then the other big piece was the entire compliance functions didn't exist in many of these banks. And if you look at the last 10 years, I would say that's, I don't know, Hank, Mark and Gina, I'm sure you'd agree that that's one of the biggest transformations we've seen in our clients. So the entire compliance functions have been developed, very robust, very large, and that as part of these settlements, the DOJ is very precise as to the headcounts and resources and budgets and their annual reports. So even post-prosecution and post-DPA, when we file these annual reports, we have to describe how robust these remediation programs are. I will switch around. I don't know if Mark and Gina, either of you want to comment on that piece, but okay. I will switch around and go to the last question I had first, just in the interest of time, since I know we don't have a ton of time. We're very lucky. We have several general counsels of banks and members of boards of directors of global banks that are attending with us today. So question that we have, if you put on your hat as a future teller, what do you see going on in the future? What lessons can we take away? Where do you think the next wave of enforcements will come?
Well, I should preface this by saying that I'm always hesitant to put on my hat as a fortune teller, especially when speaking to an audience such as the one we have today, because I have to, as an academic, I have to work based on publicly available information, which some of the cases that you are working on or aware of at the moment as practitioners may only become public years from now, if ever. So So with that caveat in place, with the information we have publicly available, what can we try to say about what the future might look like? Well, as some of you mentioned, there was a significant dip in global bank prosecutions and in corporate prosecutions in general under the Trump administration. The fines went down dramatically. And this is not very surprising. It's my thesis. Part of my thesis is that prosecutions and the priorities of prosecutors tend to be responsive to the political cycle and public concern, and both of these things kind of declined during that period. And also, most of the big cases by 2016 had mostly played themselves out. Anyway, there are a few stragglers and a few settlements that came in later, but LIBOR, FX, tax, sanctions was basically done. So we had this kind of lull for several years, and then the question is, what's happening now? With the Biden administration, many expect that white-collar crime is going to become a more active area. Maybe it's already starting to be so. But we're just starting to see some systematic evidence of what the new approach might look like, at least in public. So there have been several speeches in recent weeks by DOJ officials promising a tougher approach on corporate enforcement. Lisa Monaco, who's the Deputy Attorney General, focused on 3 points in a recent speech: bringing back individual prosecutions, cracking down on repeat offenders, and possibly bringing back corporate monitors. We still have to see how this plays out. Among these points, the one that most struck me was the one about repeat offenders, because that's the one that I think is likely most problematic for global banks. If you look amongst all of the companies that have been subject to US prosecutions over the years, who are the repeat offenders? Well, the banks are the ones that most often find themselves on the receiving end of these prosecutions time after time. So they faced, they also face unique challenges in trying to avoid this. You think of what a corporate repeat offender looks like, or what might look like in the mind of the average person, and we think about, say, a mining company that keeps spilling dangerous chemicals and doesn't fix its practices, or a company that keeps having gruesome work accidents and doesn't fix its safety practices. There are cases that are like that, and though in these cases it might make sense to treat the defendant like an individual defendant, someone who keeps reoffending and should be treated more and more harshly as things go on. Banks are not quite like this. They are very large, sprawling institutions across many different jurisdictions. Sometimes the cases that arise are, involve people who have never spoken to each other, who know nothing of each other, who are completely different units doing different things. And so it's a little bit more difficult to think about how that's going to apply to banks. Now, one has to hope that prosecutors will do that in a sensible way and look at things like, have you generally created a culture of compliance in the bank, and made it clear that there would be follow-up when violations are detected. But I think that's a big question mark as to how that priority will play out.
Yeah, absolutely.
Joydeep, if I had just to interject very quickly on a crystal ball, and I don't have a crystal ball, but we are asked to make predictions or forecast things for clients, say what's coming. And I think Professor Verdier makes this point. One area would be certainly anti-bribery for banks. That's going to pick up. And both banks as principals, and it's where they're promoting their business, and banks as facilitators, where they're secondarily liable for facilitating what their clients are doing in that field. I think sanctions is always a hot topic. It will change over years. Iran may go down. It will change and follow foreign policy. And I think to the extent that I think China will be an area of sanctions, and Russia too, maybe Iran, Cuba a little less so, but that will follow the politics. But that's a very hot, and it's a bipartisan, popular topic. And now we see that just to hook up with bribery, which was formerly more or less an AML type offense, it's still that, but it's also a sanctions, because the U.S. is sanctioning corrupt foreign officials. So you have that. I would also say that, just to follow up, that the tax issues are over with respect to the former regime, but now we have FATCA. I think there will be prosecutions involving not complying with FATCA, and the tax division is already working on that. And people probably can see evidence of that. So cryptocurrency also, in terms of new things, obviously the government is going to be, again, following policy, but also where people feel that there's other issues, criminal issues, cryptocurrency will get a lot of attention.
I think one
No,
of the
thank you.
central
Yeah.
messages, one of the central messages that comes out of the book is that prosecutors, relative to regulators in the past, are going to be a lot more responsive to public concerns, political pressure, high-profile issues. So I certainly agree with Mark, and I would add that things that are in the news tend to be the things that prosecutors end up focusing on. So fintech, crypto, alternative assets, ESG disclosures, data breaches, espionage. I think those are all things that you might think that prosecutors are going to find or look into at least.
Absolutely, and our favorite topic, Gina and I have done a webinar on this, art law. So we've seen the art world suddenly coming under a lot of scrutiny because it's one of the few places where you can buy high volume assets with a lot of anonymity, and AML and ABC issues come in there too. So we've talked to a lot of our private bank clients, which are quite concerned about enforcement wave coming there. I know we only have about 8 to 10 minutes left, so I want to make sure that Gina and Mark have had a chance to speak. So Gina, maybe you go first, and then Mark with 5 minutes each, hopefully.
Sure. So, Professor Verdier, I loved your book. I have it here too. And as you point out in your book, one of the major criticisms of DOJ in the wake of the 2008 financial crisis is that no senior bank executive was prosecuted for the mortgage crisis, and only one small bank was prosecuted. And it left in the popular mind this idea of too big to fail, too big to jail in regard to large financial institutions. And having worked for DOJ during this period, starting from 2009 through 2020, I can say that this was a criticism that we heard often. And I would have to say, I imagine that the prosecutors who worked on the cases discussed in your book, and certainly the financial institutions impacted by them would disagree with this. So that was one of the reasons why I found the perspective in this fabulous book just so refreshing and spot on. But it's this idea that in the popular mind of too big to jail criticism may have continued to ring in the ears of many past DOJ officials from the Obama era who have now returned to DOJ under the Biden administration, and has led many, including myself, to speculate about whether we might see DOJ renew its efforts to investigate banks and their executives for possible wrongdoing, just as sort of a almost of a righting of wrongs type thing, like rethinking maybe they should have taken a more hardline perspective with regard to some of these investigations. And so given that concern, combined with the additional resources that have been devoted to investigating AML violations, especially under the new legislation that was passed at the beginning of this year, and DOJ's recent announcements indicating a tougher stance towards corporate crime, I think a lot of us have taken the view that financial institutions will face an environment where they're going to face a lot more scrutiny in regard to AML investigations, and certainly cross-border AML investigations, given that the AMLA had a lot of provisions to encourage cross-border coordination between foreign counterparts in the US. And I was just wondering if you had a perspective on that.
Well, I certainly agree that there has been a huge amount of emphasis in the public discourse in the United States on individual prosecution, and I think that's one of the messages of the book, is that that emphasis may be a little bit counterproductive when we start looking at these prosecutions as part of a larger system and we try to look at whether it can lead to beneficial reforms. There is a trend of argument in the US public discourse that very much goes, we will never solve problems within financial institutions without strong individual deterrence, i.e. without individual prosecutions that lead to very substantial penalties. And I don't deny that that's an important aspect of the problem, but the concern that I have is that I go, and at some points in the book, I go through the record of individual prosecutions for things like sanctions, tax, and LIBOR, and it's pretty disappointing. There are cases where prosecutors tried very hard to convict individuals and threw a lot of resources at doing it and failed. And so I think part of the lesson here is that the corporate prosecutions, heavily criticized as they have been, are really the main event and will be the main event going forward in terms of actually achieving something in the prosecutor's relationship with the banking industry. But as you mentioned, those have all, that does not necessarily mean that this is where things will go. And I do think that there is a sort of re-emphasis on individual prosecutions that is going to come back that people have to be very aware of.
Going back to the Yates memo and all that. So, Mark, I'll let you share your final concluding remarks.
I read the ebook because I've just started traveling recently and it's better on my back. But as someone who has intensively and extensively lived through 2 of the chapters of this book, in fact, some of the things are still going on, I could really spend hours complimenting and critiquing it. But one of my compliments would be that the book really anticipates and confronts many of my critiques. So I really recommend it to anyone who is interested in this call. It makes good reading, and it's stimulating in terms of my thought process. The book describes with impressive accuracy the role and power of the prosecutors. But as the book says, just because this is the way things are doesn't necessarily mean this is exactly the way they should be. As a law student many years ago at a school that did not place much emphasis on law, teaching or learning law, I would have agreed 100% that prosecutors should play the role that Professor Verdier describes. But after nearly 4 decades of practice and actually an experience in learning law that I didn't learn in law school, in these cases, I am only really 50% on board with what Professor Verdier describes in the book. And part of what gives me pause, and that I want to just focus on very briefly, is that in some respects, prosecutorial power in these matters has gone beyond just aggressive enforcement, which can play a useful catalyst, as we've talked about. But enforcement of the law is written and has really morphed in many cases into actually lawmaking and policy making. And that also may not necessarily be something that we should condemn across the board, but I think it potentially becomes problematic where we lack effective constraints. And that's just one I want to end up with here, because in those cases, we can get interpretations of the law that actually go beyond the law and outside law and often conflict with the law as it's intended to be enforced. It can lead to inappropriate results and costs, and I include in those costs the costs of vendors, such as ourselves, outside vendors representing the banks. It also can result in international tension, and remediation is really important, but sometimes the remediation can be not exactly effective and can be misguided because it's being implemented by people that are not subject matter experts. And I think that's something that many of on this call may have experienced. But it's really the 5 lack of constraints or 4 lack of constraints that I want to focus on, that normally the traditional constraints on prosecutors are not there. And that's not the fault of the prosecutors. Well, one is self-restraint. And we're not really in an era of self-restraint, as many of you know, in our country and elsewhere. And I don't think self-restraint at one point may have been important. I think Gina's probably seen this, and less so now. But then there were outside political constraints on prosecutors. Now, it's really important when I say political. I'm not at all challenging prosecutorial independence. That's a really important value. But it may have gone a little too far to the point where prosecution, because of independence and that value and the fear of compromising that, we're not steering or managing prosecutions at a higher level. And I think that has a cost that we can see here. But one thing that's pointed out in the book, the third point, is the lack of judicial review, the lack of judicial involvement, testing positions of the prosecutors in the crucible of the courtroom. And this is a very important constraint, and for reasons that are not the prosecutor's fault, is that the banks cannot afford to litigate. Now, some of that is because of the threats that Professor Verdier they don't think they can afford to litigate. So you don't have involvement in the judiciary to say, okay, this is what the law says, you're going too far, and judging positions. I think the Swiss issue, bank issue, is one just quick example. I was in the courtroom when the John Doe summons was litigated. So there was a courtroom. And I can tell you, my view is, if that had gone to a decision of that judge in that courtroom, the decision would have favored the Swiss bank, UBS, and the Swiss government to a very high degree. But because of the various threats, the parties decide to settle without a judicial determination, which of course is their right, but that's something missing here. Professor Verdier says that, but where individuals litigate, as they did when they were prosecuted, the juries acquitted those individuals, I think almost uniformly. So the point is where one can litigate, and limited the law and limited the legal theories. So, but we're missing that in the corporate context. And I think that there should be some way to see how much we can restore that. And finally, my final comment is, I think we have to look at ourselves. I mean, outside counsel, and be somewhat self-critical and self-aware. There is a revolving door that Professor Verdier say, but there's a reverse revolving door. Now, this doesn't apply to anyone, Mayor Brown, certainly doesn't apply to Gina. And we don't do this, but many people who have served in government come out and are still serving in government. And that they're not doing the sort of zealous advocacy that the clients need and deserve. So it's not just a question of those people capturing things when they're in government, but they come out of government, and that's an issue I think we need to be very cognizant of. It's not, are we doing enough to advocate for our clients? It's not a question of confrontation. We have to be cooperative, but the cooperation is not inconsistent with strong advocacy. I think that's something where we have to look at ourselves. So, Professor Verdier, one more thing. In your next book, I would love to have you talk about the role of civil litigation to enforce this. And just one quick example I throw out there, and it's in the sanctions area, but many of the sanctions investigations you have detailed have spawned civil litigation by private plaintiffs under the Anti-Terrorism Act. And those litigations themselves can have tremendous effects, some would say distorted, but effects on behavior of banks. So I'm looking forward to that article, and maybe we can do it together.
Oh, what a wonderful idea.
That's a great idea. To two quick things, because I know we're about to go over time. One, on the point of judicial review and the lack thereof, I do think in the prosecutorial decision-making process, there is a strong consideration of how a jury would view evidence. And it's, Joydeep, as you pointed out, the mens rea element, the willfulness that prosecutors have to prove in a lot of these matters. It's a tough bar to overcome for prosecutors. So I don't want anyone to think that, people are just sort of DOJ are shooting from the hip and like, we'll see how it goes. Nobody's going to ever take this to a jury. I mean, there's a very serious consideration given to the quantum of proof and what will convince a jury. And I think that's why you've seen a limited number of individual prosecutions and maybe not as many institutional prosecutions that again has generated that popular criticism of too big to jail. So that's my first point on the point of lack of judicial review. The second point about the revolving door, I have to say, I mean, I see where you're coming from, Mark, but having been on the DOJ side, some of the strongest advocates I've seen come before me in a conference room asking for a settlement are former DOJ people, and because they know where the pressure points are. And so, maybe because I'm a former DOJ person, a little bit touchy about the revolving door criticism, but I do think it's by far, I mean, the people who are the strongest advocates have been former government people because they understand the thought process. So I do think, to be fair to the former government outside counsel folks, I think that they've done a really strong job of being zealous advocates.
That's certainly true of Mayor Brown white collar people.
To this. I think your points are very well taken. This is a new system that's been evolving sort of organically, and reality is, as you point out, is that a lot of the checks and balances that exist in the traditional prosecutorial system are not quite there. So what will replace them, or can something replace them? And one thing that comes to mind is that with respect to the policy making aspect of this, It's true that we now have prosecutors who are not necessarily knowledgeable about the banking industry making a lot of these decisions. But what's happening, as Joydeep and others pointed out earlier, is that you have other countries developing the same capability and becoming more involved. So that can help bring the perspectives of other stakeholders into the mix. And another trend that I think is important is that the regulatory agencies who had kind of been pushed out of that process early on have been brought back into the process, participating earlier and taking part in designing the reforms and monitoring their implementation rather than, for example, going to external monitors or relying on the prosecutors themselves. So I think what's evolving over time is a system in which other stakeholders are being brought back in, other kinds of expertise are being brought back into the system. And so maybe that will provide some checks and balances in a different way than they existed in the past.
Liz, I'll let you conclude.
Well, first of all, I'd like to thank all of our speakers, but especially Professor Verdier. You really have written something that has stimulated assessment, thought, and I know I leave the session today wondering what's coming next. It really seems to me like some massive movement has occurred. And I just wonder where those regulators and those private litigants, what role they will play in the next 10 years as this starts to settle and turn into perhaps a framework that is more predictable, perhaps not. I also am very conscious of how much of the world's money we're talking about. It just seems to me this trend that we described today affects every business in the world because we're talking about a vast proportion of the world's assets. And I think for that reason, it is particularly, this particular session is something that we appreciate partnering with you on because of how relevant it is. I look forward to our continued collaboration with you, Professor Verdier. And for our audience, we look forward to continuing to stay in touch with you and to elicit your views directly from where you are seeing the impact of these trends. Thank you, Joydeep Sengupta, for organizing us today. Thank you, Gina and Mark, for your incredibly expert insights. And we look forward to meeting again for stage 2 in the near future.
Goodbye.
Thank you very much.